We are very fortunate to have with us today Professor Ryan Abbott of the School of Law at the University of Surrey, about 35 minutes outside of London, as I understand. Robert Atkinson, founder and president of the Technology and Innovation Foundation. Professor Michael Smith from Heinz College at Carnegie Mellon University, and Marian Underweiser at Senior Counsel at IBM Research. We are going to hear the panelists' presentations and then have a discussion among the panelists and then look forward to your questions for the group. Professor Abbott?
Today's machines are getting very good at playing games. In honor of our IBM panelist, I included a picture of Watson winning a game of Jeopardy in 2011, which is ancient history now in AI terms. Last year, Alphabet's DeepMind algorithm beat the world champion of the board game Go. That was significant for a lot of reasons, but it was also the last traditional board game at which people could outcompete machines. There is still some uncharted territory. It's working on StarCraft 2 now, so I tell my students when I see them playing StarCraft in lecture, they're wasting their time, but those were the ones not listening to me anyway. And of course, Google and IBM aren't investing in game playing to dominate traditional board games, but these systems are already being used to apply to practical challenges, including making new works of intellectual property. In fact, that's a good chunk of the Watson Insight business model. Watson is a group of algorithms owned by IBM. Clients give big data to the algorithm. IBM runs it through the algorithm. The algorithm produces insights. Those insights are sold to the clients. Clients have the right to patent those insights and own them. The contract says the patents go to clients, but in patent law, ownership of inventions goes first to the inventor. It's not clear there the clients would be the inventor just for handing over data. IBM can't be an inventor because companies can't be inventors. It also isn't clear that the people who programmed Watson, fed it data, or asked it a question would qualify as inventors. Some of the time, yes, but some of the time, not so much. In some cases, what we traditionally think of as the conceptual work of an invention has been done by the machine. And what to do with these intangible products of the mind created by machines are one of the exciting challenges we have yet to address. There isn't much law on the subject. There's more on the copyright side. The UK was the first country in 1988 to provide for copyright protection for computer-generated works. They belong to the producer of the work. There's only been one case looked at under this statute, and it didn't really consider authorship. The US, by contrast, has a Copyright Office policy from 1984 that says non-human works are not eligible for copyright protection because it thinks that machines lack the ability to come up with mental works. Also, it thinks monkeys do, but we don't have time to talk about the monkey selfies. On the patent front, there's significantly less law, approximately none at the moment, despite the fact there's credible claims of machines having autonomously invented things since the 1990s and thereafter. And a number of businesses are claiming this is a significant part of their business model. In the case of the creativity machine, which was a neural network-based machine, which in 1998 autonomously generated an invention that received a patent, the patent office issued the patent in the name of the human owner of the machine because he hadn't disclosed the machine's involvement. And so the patent office has never considered what to do for a potential machine invention. Of course, most machines aren't involved in inventions as autonomous inventors. Mainly they're just tools, and people can use tools without messing with inventorship. So if I'm really bad at math and I use a calculator, that doesn't make the calculator a co-inventor. Similarly, I could ask a person to use an abacus to multiply some numbers for me. That doesn't make them an inventor either. Even if I have someone contribute more substantively, like I ask a machine or a PhD student to carry out an experiment that I've designed, if the machine or the PhD student doesn't alter the experiment and the results are along my predictions, that wouldn't make them a co-inventor. But if you just ask someone to solve a problem, so you ask Siri to design a better semiconductor, or I tell my PhD student I want her to design a better battery, and she does, that generally would make them an inventor and not me. So the ways that machines are now able to contribute to problem solving is analogous to the way people are solving problems. And if Siri was a natural person and you asked Siri to design a better battery for you and it did, that would make Siri an inventor. Of course, Siri isn't human, so it begs the question of whether a machine could be an inventor, whether a machine should be an inventor. And this is important practically as well as theoretically because machines are functionally inventing, inventors have ownership rights in their patents, and failure to list inventors can make patents invalid or unenforceable. And the fact there's no law on this is problematic, and why I suspect you're not hearing more about it. In the absence of a law permitting or prohibiting this, it might be, as with the Copyright Office's policy, that computer-generated patents are unpatentable. Although there is no statute that specifically addresses this, there is a lot of judicial language referring to mental acts, which might seem to suggest a person, and some statutory language about individuals, largely dating to the 1950s, which was likely done to get rid of corporate inventorship or prevent corporate inventorship. I think that not only should we protect computer-generated works, but we should recognize algorithms as inventors. And the reasons for that have to do with incentive theory, because even though computers don't care about incentives, the people building computers do, and what we want to do is to be incentivizing the development of creative computers and inventive machines, because in the long run, that will generate more innovation for all of us. It would also acknowledge moral rights of human inventors by preventing people from taking credit for machine inventions. So if you ask Siri to design a better battery for you and it does, you wouldn't be able to list yourself as an inventor, whereas a person who did genuinely inventive work on their own would. And acknowledging machines as inventors would reduce gamesmanship at the patent office. If a machine could be an inventor, who would own the invention? Well, I'm not saying that the machines would own inventions. They're property. They don't have legal rights. I think the best way to do it would be to make the machine's owner the assignee of any patents generated by the machine. And when you have developers and users and computer owners all in the picture, they could work out alternate arrangements by contract. There may not be all that much autonomous machine invention right now, but computers are improving exponentially while people are not. And it suggests that in certain areas, at least, and for certain types of problems, machines may be the standard way that R&D is conducted in the not-too-future. Watson, for instance, is looking at new uses of existing drugs, which often involves pattern recognition in very large data sets, a task at which machines have a significant advantage over people. And so it may be that people aren't able to do that sort of work unaided not too far in the future, and that Watson's the primary way that we find new uses of existing drugs. And if inventive machines become a standard part of the R&D process, that challenges another one of these established concepts in patent law, the person of ordinary skill in the art. So inventions are granted for new, non-obvious, and useful things, and the primary bar to patentability is the non-obviousness requirement, which is the primary means by which we separate trivial advances from significant inventions. We don't want to grant patents on trivial advances that would have come about anyway, because they have significant social costs. We want to, ideally, economically, grant patents on things that would not have come about but for patent protection. That's the inducement standard, at least theoretically endorsed by the Supreme Court. And we determine this non-obviousness question from the perspective of a skilled person, and we ask whether a skilled person in a field would have found a patent obvious. The skilled person's a little tricky to define, but it matters a lot. If a skilled person's a moron in a hurry, then pretty much everything looks non-obvious. If a skilled person is a room full of Nobel laureates, very little appears non-obvious. And to oversimplify in the interest of time, the skilled person's basically the average worker in a scientific field. So for everyday inventions, a skilled person might be a person with a high school degree and a couple of years of practical experience. In the life sciences, maybe someone with a master's or a PhD and years of graduate experience. Incidentally, I took a picture of the London commuter to represent the average person, and this was the happiest group of London commuters I could find in a picture. Also critical to this non-obviousness test is prior art, which is our existing body of knowledge. The test considers for non-obviousness what the skilled person would have found obvious in light of relevant prior art in that field or related to that problem. And that's an important restriction because almost all inventions on some level involve a combination of existing things, and so it would be burdensome if we considered that a skilled person knew everything about everything. right? But if the skilled person represents the average worker, and if inventive machines are now supplementing the average worker, inventive machines don't have those same sorts of field distinctions. There's no reason why Watson couldn't look to culinary sciences as well as life sciences when looking at new uses of existing drugs. And so the fact that inventive machines are going to become involved in this suggests not only is the skilled person becoming more sophisticated, the skilled person's scope of prior art is expanding also. And once inventive machines go from augmenting the skilled person to automating the skilled person, this is going to really change things. Because instead of research scientists using DeepMind to answer questions, DeepMind is going to start routinely doing the conceptual part of the research. People will give problems to machines, and machines will autonomously generate solutions like, can this drug treat this condition? What can this drug teach? What can you tell me about my drug portfolio? And at that point, when the average worker becomes, for all intents and purposes, an inventive machine, the skilled person should be an inventive machine. So instead of Exxon asking its research scientists to develop a better catalyst, they just ask DeepMind the way you'd use Google Maps to ask how to drive to Manhattan. And I think this approach is going to be inevitable, particularly in fields where computers have a significant advantage over people like pattern recognition in big data. And it may happen very quickly, because once machines exceed people, they'll be able to scale up as Uber is hoping self-driving cars will very quickly replace their contractors. That's something patent law is going to have to deal with, because being inventive is always supposed to be the exception. And if inventive machines are standard in R&D, it's no longer going to be exceptional, which means that inventions are just going to be happening routinely, and that creates problems for patent thickets. And I think the solution to this is to change the standard from the skilled person to the inventive machine when that happens. It's a higher standard, it's a more sophisticated entity, it's a more knowledgeable entity. Of course, it's hard to figure out what an inventive machine would find obvious. For that matter, it's hard to determine what a skilled person would find obvious. There's a lot of hindsight bias in that test. There may already be good reasons for departing from our traditional skilled person standard now, but once inventive machines are in the picture, we may really need to, and to have a test that focuses more on reproducibility or economic factors to determine non-obviousness. And once the standard for patentability is obvious to an inventive machine, it's going to be really hard for other machines to compete with this. As the standard rises, it may be that access to big data and confidential sources of data gives a competitive advantage. After Deep Blue defeated Kasparov in '97, and after he regained his composure, he had a pretty bright insight, which was, all right, a machine can beat a person, but I bet a machine plus a person could beat a machine, because human grandmasters are really good at long-term strategy, but really poor at seeing millions of moves in the short term. And so he figured that both of these could combine their strengths, and really you'd get the best performance out of a person plus a machine. And he was right about that. In the first Centaur chess tournament, which he won, a person plus a machine beat a machine. At least he was right to a point, because last year the chess engine Zor beat the leading human plus machine. And so at a certain point, people just get in the way. People are going to have a really hard time competing with machines. If you think about monoclonal antibodies, and all the leading biologic blockbuster drugs are monoclonal antibodies, there are a lot of possible antibodies in existence, or that could exist, enough for the body to do what it needs to, but there's only so many ways you can string proteins together to make an antibody. And it's not that hard to imagine a sufficiently powerful computer just sequencing every conceivable antibody and publishing those online. And under current standards, it couldn't get patents on that without knowing their utility, but if it was an anticipatory disclosure, which it probably would be, you couldn't get any more patents on antibody compositions. Right? And so in field after field like this, human inventors may be shut out. Even machines are going to struggle to invent with an inventive machine standard as they exponentially improve. So the DeepMind of 2030 should dramatically outperform the DeepMind of 2025. And with no limit to the sophistication of computers, there's really no limit to how skilled they can become. To a super intelligent machine, everything will be obvious. And the end of obviousness means the end of patents as we know them now. That might be okay, because with a bunch of super intelligent machines, the cost of innovation should plummet. And to the extent that we want patents for other sorts of things, like promoting commercialization of new drugs, where, as we've heard about earlier, you have long development timeframes and need market exclusivity, we have other means of doing things like market exclusivity for new drug approvals. Thank you.
Thank you. You know, as we think about Professor Abbott's comments, I always think we should take refuge in the fact that the astronauts beat Hal. So, Mr. Atkinson.
Only some of the astronauts beat that.
Okay.
Okay, great, thank you. It's a pleasure to be here. I am not a lawyer, and I'm going to talk more about this question from a policy perspective of how we're thinking about these questions of data and intellectual property and innovation, which is an area that is going to be, I think, increasingly important. We're already seeing Europe going down certain paths here that I think are going to be very problematic, or at least considering going down paths I think will be problematic to innovation. So, okay. So I don't think there's any doubt that we're living in a world where there's a lot more data, and data is becoming more important, partly because we're able to generate a lot more data from machines, whether it's sensors or better computers. But also, the value of individual data is becoming more important as algorithms get better and can continue to develop insights around that data. So data is going to be more and more central to a lot of these questions around intellectual property in ways that it really hasn't been in the past. And it's not just an intellectual property question, I would argue, that's all wrapped up in this, at least from a policy perspective. It's really two other issues. One is privacy, and that gets all wrapped up in sort of who has rights to data, and the rights aren't necessarily legal or intellectual. They're not intellectual property rights, but they're seen as privacy rights. And the second is competition policy, where there is an increasing view that data gives inordinate amounts of market power to certain kinds of firms. So how should we think about data? When you go out and look at sort of how people are writing about data, none of the analogies really work very well, at least for the concept of intellectual property. People talk about data, sort of the most common metaphor is really about oil, but oil is rivalrous and most data is non-rivalrous. So it really doesn't sort of give you a guidepost to what to do. Sorry. Okay. The second, let me see, how do I go back here? Okay, I don't. The second is really around oxygen. People have used that term. Data is like the new oxygen. It's all around us and it permeates everything we do. But that's really not the right metaphor or model either, because oxygen is non-rivalrous, is not excludable. Data is certainly excludable. While it's non-rivalrous, it's certainly excludable. Some people talk about data as infrastructure. So we're going to have data all around us. A lot of it's going to be public, just like we have infrastructure of roads. And that's not the right model either, because some data is public. You go get NOAA data and understand the weather, but lots and lots of data are private. So infrastructure is not the right model. So I don't think there is a good model to think about. I think we just have to sort of think about data as being data and not trying to analogize it to something else. So the big question, I think, is that a lot of people are looking at now is how should we, let me see if I can get back here. There we go. How should we think about individual data? So there's really kind of two kinds of data, if you will. There's personally identifiable data or data from a person, and then there's essentially machine data. And they're really two completely separate concepts for thinking about ownership for personal data and machine data. With personal data, though, we are seeing this this rise that's becoming quite widespread, that individuals should own their own data. And that when you share data with a company, they have to give you the rights to that data, and that Some go as far as would argue that these companies have no legal rights to the data that you provide. As Commissioner Vestager says in Europe, you're giving away something valuable. You may be giving it away, but you're actually trading it. You're not forced to go onto Google or Facebook or any of these other sites. So you do that because you're getting something of value. In exchange, you're giving something. Doing that, though, would have a significant negative impact on innovation. If we give individuals rights to all of their data and say that companies don't have any rights, that would be sort of the most extreme view of that. The end result would be that it would be incredibly difficult for companies to monetize the value of that. And we see that in Europe, where there's a study by Catherine Tucker at MIT and Artie Goldfarb at Toronto, where they looked at the effect of the European privacy rules, pre-GDPR, by the way, so that tells you sort of how bad GDPR is going to be. Pre-GDPR, they found that the ability to monetize eyeballs on a website in Europe was about 50 to 60% less than in the United States, because companies simply had no idea they had very little knowledge of who was looking at the website. Was it a man or was it a woman? Was it an older person? Was it somebody interested in a vacation or somebody interested in tennis? In the US, companies have a lot more insight. They don't necessarily, and almost always don't know your name, nor do they care what your name is. They do care sort of having some guesstimate of what it is you're interested in, so they can serve you up an ad that they can charge 5 times more. This is why if European internet ecosystem had the same ability to monetize eyeballs that the US does, they would be making $11 billion more in internet ad revenue, which is more than double what they make. So it's a big, big deal, and sort of saying that somehow we should give people ownership of data, which is essentially what the GDPR does and what some of the proposals, if not many of the proposals in the US would do with upcoming potential privacy legislation. So I think the other component of that is we tend to have this all or nothing view of personal data, and in reality, personal data really is, you can argue there's 4 kinds of personally identifiable data, and I think it's important to segment out each of those in order to think about who has rights. One would be observable information, so things like a video or an email. I've written an email, or I've made a sound recording. These are all data. Clearly, in many, if not most of those cases, the individual who created that data should have exclusive rights to that. But then you're talking about a second kind of data, which is observed data. Things like where I was born, what websites I went to, where I happen to be when I'm using my phone. The question is, who should own that kind of data? And I think the question there is really who contributed the most amount of labor to that. In some cases, there's a lot of labor that the company on the receiving end of that puts into that data. They don't just sort of take it. They do things with it to create better data. And so clearly the business on the other side of that has some ownership rights, if you will. There's also observed data, which you could think of things like network traffic data, just sort of knowing, or SSID identifiers in internet. These are sort of personally identifiable, but again, really here, it's sort of data exhaust, if you will. It's not central to who a person is. So again, clearly in those cases, a company should have the rights to use those data. With computed information, this would be things like advertising profiles that companies put together, or credit scores. These are clearly areas where the companies developing these are using a lot of resources, sometimes interesting and proprietary algorithms, but certainly a lot of work to create that data and to put it in a form that's special. Clearly, they should have ownership rights to that data. And then the last would be associated information, where the organizations that produce the information, again, should have the rights to that. That doesn't mean that in certain in cases, like for example, if Google has the right to know about what my birthday is, that I don't have that right as well. But a lot of the data, a lot of the arguments on personally identifiable data really go to sort of exclusive rights. And we just argue that would be a very destructive, negative thing, I would argue, for continued innovation. Companies put a lot of time and effort and get value out of that data. When you come to non-PII data, which is usually business data, interesting question there. You would think that would be a pretty straightforward case where you just would say companies own it. But in case take, for example, a sophisticated machine now in an internet-enabled device in a factory where that machine is generating large quantities of data on a per-second basis on things like machine performance. Who gets to own that data? Is it the company that sold the machine to the factory? Is it the company that integrates those machines? Oftentimes you'll have a factory, almost always multiple different types of machines made by different companies, and there'll be a company that integrates those machines into a single system. Is it them, or is it the company? And why I think that's an important policy issue is you're seeing a bunch of countries now, not surprisingly non-American countries, like Japan and Europe in particular, who are essentially worried that U.S. companies are going to have it's a little comment, a little similar to our paper this morning on looking at what countries are doing around IP and forced royalties and the like. It's a similar kind of approach. We don't want to have foreign companies controlling this data and being able to exert terms of service, commercial terms that would make it more expensive for our domestic companies. So we see that in Europe now, where they're considering and I say considering because I don't know that they're going to do it, but they're certainly talking about it, that there would be laws regarding contracts that would basically force ownership rights to the buyers of machines. I think that's really, again, it's a bad idea for several reasons. One is it's premature. I think in many of these cases, we just don't know how the business models are going to shake out in here. There could be business models that are just where the owners of machines have all the data, and because of that, are able to dramatically drive innovation in how machines work and how they're built and how they're operated. We just don't know yet. And the second thing is that, at least currently, the model is almost always, I don't want to say always, but it's almost always, at least in factories, where the companies who buy the machines just sign contracts to keep the data. And so I don't think we really need any kind of government involvement here that would sort of dictate that business model. There's no evidence that you have monopoly sellers in machines, and even where you have where you have oligopolistic sellers, like in jet aircraft engines, where now a jet aircraft flying from here to Brussels or something like that generates terabytes of data for each engine on each flight. The market has worked that system out quite clearly in terms of who gets to use the data and who gets to benefit from it. So I think here, in this case, if we were to go down this path of trying to regulate these market relationships, there's no evidence that there's any market failure, but I think there is evidence, or at least logic, that there could be a significant risk. The second or third big area we see now is a big push for forced data sharing. So there again, this all largely is around big tech, if you will, and so Google is seen as a monopoly, Facebook is a monopoly, maybe IBM has too much data, who knows? All these companies have way too much data. And therefore, they're going to use that monopoly power to hurt competition. And so the focus is, why don't we force them through a government dictate to share data? And this article by Victor Meyer-Schoenberger and Thomas Ramge basically say the government will go to these companies, will tell them they have to share 12% of their data and go in and monitor actually the data they're sharing so that they're not giving bad data but good data. You know, we're talking a sort of unbelievable kludge of big government here in order to get competition. Really, I think bad idea for several reasons. One is privacy. Most of the big companies have a big incentive to maintain privacy. That's not to say they're perfect about it. Second, it reduces incentives. If you know that you're going to do a lot of work on at least curating data, if not collecting it, you're going to do less of it, and obviously very difficult to administer. And lastly, is a report my colleague Joe Kennedy wrote recently, really very little evidence that data gives you a sustained competitive advantage and that there are data monopolies out there. I think it's a claim that really has very little support to it. Another area would be forced access. Now, this is going to sound exactly like I'm saying the opposite thing here, but I'm not, is what you're seeing is in a bunch of industries that are able to collect personally identifiable information, they're using that and the unwillingness to give consumers machine access to it through what are called APIs, application protocol interfaces, programming interfaces. They're using that as a way to keep monopoly power. And the best, or keep market power. The best way to think about that is in fintech, where there's a lot of fintech applications out there where you want to give your application, your fintech application, you want to give them the ability to go and using an API, get your data from your bank or from your insurance company or whatever it might be. And the banks and insurance companies and others are holding that back and not allowing it. And I think, to me, that's just purely anti-competitive. That's an area where government could and should act as a way to ensure more competition. And the reason I say that is it's because it's the individual's data. I'm not saying the government should force the company to give data of their own, but this is really allowing consumers to have access to their own data and then being able to use it to drive competition. I will just stop by just saying lastly, I think this is in many ways not very similar, not very different than sort of traditional debates on IP, where you have, to oversimplify, you have the progressive left who looks at sort of short-term consumer welfare issues, sees this as really a way to fight power. You have others, defenders of IP, who look at it as really around dynamic innovation, dynamic effects and longer-term innovation. I think that debate is quite similar for this, with the added layer of now the whole international thing where a lot of countries look at the U.S. as sort of the holders of data monopolies, if you will, the holders of data power, and using their laws to make it harder for our companies to be able to effectively compete. Thank you.
Robert, thank you very much. I would call your attention to a Supreme Court decision in the last session called U.S. versus Carpenter, which talked about cell phone location data and basically said, in a 5-4 decision, the majority said it is so wrapped up in your personal life that it should have a search warrant, and the other 4 said, hey, it's not your data, it's the telephone company's data, and therefore there can't be a search since it's not your data. And that was a very tightly decided decision, but it shows how we're going to have many of these kinds of fights to come. And now, we're very pleased to have Professor Smith.
All right, thanks. This is a talk. I want to talk about a paper that I'm working on with my colleagues Rahul Talang, Matea Nadaro, and Tommaso Valletti, looking at a real-world experiment in the UK to test the effectiveness of anti-piracy regulation. So what Rahul and I are really passionate about is thinking about how technology is changing the entertainment industry, and a lot of that has to do with piracy and copyright. So in this talk, what I want to talk about is what I think is a specific example of using the availability of data and the opportunity to run experiments to inform policy, and then zoom out a little bit at the end to talk about what principles and processes I think we need to put in place to do that at a larger scale. Okay? So the policy question here for us is, are anti-piracy efforts at all effective at changing consumer behavior? And you can make perfectly reasonable arguments that they will be and perfectly reasonable arguments that they won't be. Inherently, this we would argue is an empirical question. And more than that, it's an empirical question with strong entrenched views on both sides. There are people who believe every anti-piracy regulation is great, and people who believe every anti-piracy regulation will lead to the end of the world. What we'd really like is something where you can have a more objective take on these. There have been a variety of academic studies of this, but as I'm going to argue in a second, they are of necessity using available data, available observational data, which comes with all the challenges of analyzing observational data that you would expect. What we'd really like are some real-world experiments that until recently was very hard to conduct, and recently has become possible. So let me talk a second about some of the anti-piracy studies that are out there. My colleagues and I had a paper that looked at a notice sending law in France, the Adopi law in France. And what we did was we compared music sales in France to a set of control group countries, UK, Belgium, Germany, Spain, before and after the law was discussed in Parliament and then went into effect. And what we found is that sales in France went up by about 20% relative to the control group countries. But interestingly, the increase in sales occurred before any notices went out. That the increase in sales was really predominantly around the education, around people in France becoming aware this law was going to go into effect and that there were penalties associated with this. The second set of studies look at website shutdowns or blocks. Brett Danaher and I have a paper that looks at the shutdown of Mega Upload. This was, if you're not aware, you can ask your kids, a very popular piracy-enabling site that was shut down worldwide. And what we see in the paper is that after it was shut down, digital movie sales went up by somewhere between 6.5% to 8.5%. In terms of website blocking, there have been a couple studies of blocking the Pirate Bay. Both of those studies found that blocking the Pirate Bay had very little impact on consumer behavior. And again, my colleagues and I have a paper recently that confirms that result in the context of the UK. But what we find is that when you block just the Pirate Bay, there's very little change in consumer behavior. But when you come back later and block the next 18 most popular sites and the next 53 most popular sites, that's when people start to move towards the legal options. So I think in general what we see is piracy does have an impact, or anti-piracy regulation does have an impact on consumer behavior. What I would argue is you can criticize any of these papers. So again, in our case, you've got to hope that the sales patterns in the UK, Belgium, Germany, and Spain were going to be relatively similar, and that any change you see from that control group is actually causally related to the law. Same thing in these other areas. I've got to, in the mega upload shutdown study, what we did is we compared countries with high mega upload use to countries with low mega upload use, under the assumption that the countries with high mega upload use before it was shut down would have a larger increase in sales. But again, you've got to assume that those countries were going to be similar anyway. What you'd really like to do is have a real-world experiment, where instead of relying on being able to manufacture a control group, that you manufacture that control group right up front. And what I think is sexy, if you allow me to say that in the context of an economic study, about what we're doing here is we have that opportunity to do that. So here's the research setting we have. We're looking at a law that went into we're looking at a partnership between rights holders and ISPs in the UK that started in 14 with an announcement that rights holders were going to pass along copyright notices and ISPs were going to send those notices on to end users. This started in November 2015 with a public education campaign that you should try to get your copyright material from legal sources. And then in January 2017, they started to send these individual notices to households. The first notice basically said, hey, somebody's using your network to steal copyrighted files. Maybe you should change your network configuration so that doesn't happen. The second notice said, by the way, you're still doing it and there are legal opportunities out there. And then the third notice says, by the way, you're still doing it, and the rights holders can take you to court, or your ISP can impose penalties on you for doing this. So relatively minor penalties for this. The empirical challenge is, unlike these other settings, the notices weren't the only thing that was going on in the UK at this time. At the same time these notices were going out, we were also seeing countrywide site blocks, the same ones we were analyzing in the other studies. And that's going to make it really hard to do a before-after or a UK to other country comparison. What I really need is something where I can compare areas within the country, areas within the UK to each other. And so what we had the opportunity to do was to partner with Creative Content UK before they started sending out notices to say, let's assign different parts of the country to a control group and to a treatment group, where the treatment group will get the notices and where in the control group you will intentionally not send the notices. And what we did was we broke down the country at the 3-digit postcode level. Ryan will be able to explain what that is. But you know, it's unlike the US zip code, the postcodes in the UK are actually much more organized. So the 3-digit postcode defines about 2,000 unique postcodes in the UK, each of which have about 2,100 or 21,000 people living in them. So we put about 80% of the country in the treatment group, about 20% of the country in the control group. And then started sending out notices. So this is the data we have. We observe the total number of copyright infringements in a 3-digit postcode per month. So we see this from January 2016 to the present. This is basically going out and looking at IP addresses that were found sharing copyrighted information. We've got consumer infringement reports. These are incidents where the rights holder actually goes to the trouble of claiming that piece of content and issuing a report to the ISP. And then we've got the number of email notices that the ISP actually sends out to the end users. We got legal consumption data recently. We're still analyzing that. What I'm going to show you is just the piracy data. And I'll give you a little hint that we're seeing similar results in the legal consumption data, but they're not quite ready for prime time. Okay. So if you buy the setup, the econometrics are actually pretty straightforward. So this is a chart of the number of infringements, the average number of infringements in the control and treated postcodes before the law went into effect in month 13. And after the law went into effect. And what you see is that they sure look pretty matched in the before period. And then in the after period, it sure looks like the number of infringements in the treated postcode goes down, and it sure looks like it goes down by more over time. You can run a test of this. So, you know, if you're following the setup, this is just going to be a straight difference in difference. We're going to interact this with the quarters the quarters after the law goes into effect to see whether the impact changes over time. And just for fun, this is what you get. So the way to read this is this is the change in the average number of infringements per postcode. And what you see is that it's negative in each of the quarters after the law goes into effect, and it becomes statistically significant in quarters 3, 4, and 5. What this means in terms of levels is that there was, in quarter 3, there was a reduction of about 161 observed infringements. And on average, the baseline level of infringements was about 3,400. So there was about a 5% decrease in infringements, and this rises slightly in quarters 4 and 5. What does this mean in terms of impact? Well, between 161 to 2,205 drop in infringements times The number of postcodes means that there were about 2.1 million fewer infringements in quarters 3 and quarters 4 in the UK. And if you divide that by the number of emails that were sent, what this means is that every email that got sent to a household resulted in, on average, 6 fewer infringements observed, which I would argue is large but plausible. Okay. Last point. Again, we're kind of excited. We think this is the first countrywide random experiment to test an anti-piracy law. There's a large decrease in infringements. And again, this is over and above what we would expect to be a decrease in infringements from anti-piracy. What I would argue, and this now is zooming out, is the really exciting thing about this is we now have opportunities for partnerships between academia and policymakers and industry to look at these things. So when we talk to businesses about how do you use big data in your company, what we frequently say is your instinct is going to be to focus on the systems and the data and the algorithms, and you shouldn't ignore those things. But the really hard part of using data is actually putting in place the human systems and the human capital and the culture that'll allow you to use that data to influence your decision making. I would argue that something very similar applies here. In a policy realm, that we need to think really hard about how do we put together the systems and the culture that will allow for these partnerships to occur, where we can take the data that's available and funnel it in to the policymaking apparatus. And with that, I will turn it over to
Michael, thank you very much. Appreciate that. And batting cleanup is Marian.
Thank you very much. You've heard certainly a lot of important issues dealing with the avalanche of data that we all have to cope with today in our daily lives. I wanted to talk about a particular aspect of this that I deal with in my daily life at IBM Research, and that I think is somewhat unique to what we do. Because we really are a research institution, but one that, as part of a commercial entity, is doing work focused on our customers. And it's really a unique kind of blend of research and commercial application. And it leads me to the topic of convergence. I thought I was really going to have to do more work to explain what this means, but you've actually heard a lot about this yesterday afternoon and this morning. And when I think about convergence, I'm talking about really the intersection, the combination of innovation and research and work in fields that you normally think of as separated. And when they come together, you see differences, which I'll talk about, in how innovation is done and what kind of innovations result. And I think this happens increasingly in all industries, and it impacts how we actually impacts our business model, but it also impacts how we protect those innovations, how we provide incentives. And so towards the end of my presentation, I'll cover some policy issues that are related to this. Standard disclaimer, the views I'm expressing are mine and not those of IBM. This is not legal advice. I spent a microsecond on that. Okay. Big data. So when we talk about big data, we think about the actual giant corpus of data that we're dealing with. But in many instances, the data that we think about here is not something that in and of itself is new. What's actually new is our ability to access it and to analyze it, and that has led to the development and the importance of artificial intelligence, right? So that's part of what we think of when we think of big data. Now, how did we get here with big data? The way we got here was through advances in information technology. So I've listed some of the usual suspects. I think you all know about GPS. We certainly had lots of ground traffic and air traffic, and we weren't able to really get our arms around this and use it for the kind of purposes that we do today, that we apply from AI. And I think we're all pretty familiar with what we get out of GPS. You also, I think, I've heard a tremendous amount about the Internet of Things enabled by RFID technology, and IoT applications are found in smart home and power grids. So we're talking about being able to instrument things like literally, not only traffic lights, but, shipping containers and trains and your power supply and your water supply. And all of these things pre-existing, but the enormous amount of data that you get from being able to instrument these things is what's really changed our ability to innovate. And smartphones, of course, we talked about that. A lot of that's personal data. And the other aspect that enables this that we also all take advantage of at this point are developments in communication, including the internet and cellular communication networks. So, it's in terms of the life cycle of the data, we decide what data we're interested in. The data is instrumented. We're able to actually collect this data, and through all these different means, we're able to communicate the data. And we now have increasingly sophisticated methods of analyzing that so we can use it for whatever purposes that we might have. So these are examples that I actually took from some IBM projects. So I won't speak to all of the Watson and IBM examples that previous speakers have raised, but these are some interesting examples that show you where our innovation is occurring today in life sciences, health informatics, which shows you, this concept of convergence, right? We're collecting all of this data. How can we use all of this data? Tremendous amounts of, lots of applications in life sciences through machine learning, medical imaging, and analytics. And there's an example that I think one of the speakers raised, I think it might have been Professor Abbott, I'm not sure, about the collaboration that we have with Medtronic for investigating diabetes treatment. And Henry talked about some of these earlier as well. So some of these kind of examples of where big data and life sciences intersect each other, drug discovery and development. I talked about smarter cities before. There are applications in resource planning and management, and in infrastructure and in managing people. And in oil and gas, there's a great quote here from one of our customers in Woodside Energy that shows you how the collaborative approach between information technology and data scientists and people working in a field like oil exploration actually achieves a much more synergistic result. He said, "We teach Watson to think like an engineer. Watson teaches us to think like 1,000 engineers from 1,000 sources." So I think the point is made here about how instrumentation and data collection work to the advantage of some of our customers. One way people talk about this, and I think you've probably heard this many times, is that every company is a big data company. So something I used to say even 10 years ago or 15 years ago is that every company is a software company, right? Innovation and operation and development and all these different fields depended on software. Anti-lock brakes, right? I mean, even early on in diagnostic methods, manufacturing processes, semiconductor manufacturing, a lot of software innovation, helping people make their products better. But in our current age, when we have all of this data instrumented, and it gives us the opportunity to collect all these insights and apply them to our innovation, it actually transforms what kind of products you might want to produce, where you might want your innovation to go, right? So if you put every company as a big data company, you plop this into Google, you'll get many, many, many thousands of hits. And what you'll find out, so there's a friend of mine who works at Tesla, and you can look up Tesla and see what they're doing with big data. And Tesla will tell you, they will tell you we're all about big data, right? And why is that the case? They're collecting a lot of data from their cars. They're very interested in the self-driving car market. We've heard people talk about Uber. And they recognize that the data they're collecting from their drivers about other drivers, how do other drivers interact with their car? How does their car accommodate wear and tear? That this is maybe more important, as important, maybe more important than the actual cars they're selling, right? So they understand that. Many, many companies, you can just, I'm sure there's thousands of examples on the internet where people say that the data I'm collecting is more important than my widget, right? Because it's applicable both to the next generation of innovation and to what everyone else in the market is doing with those widgets, right? With their own version. So clearly very important to be able to work at this intersection of these fields, right? So what happens to me at IBM? Well, I'm an attorney at IBM. I manage a big group of attorneys, and we're responsible for, writing all the contracts that our researchers want to do to work with other customers, to work with customers in all different industries. And they will come to me and say, why can't, I'm using the standard IBM template here for this. It's not working. So clearly we've had to take a different approach with companies that think about IP in more terms of exclusivity and confidentiality. I'm sure that you've heard the model in the IT industry. It's a networked industry. We, in the past, worked on a cross-licensing model, right? Non-exclusive licensing across the industry, very often working with open standards and open source, interconnectivity, interoperability. These are areas where you have to think about certainly collaboration, but collaboration from the standpoint of being more open across your field. In a field like life sciences and some of the other manufacturing fields, I mean, it's not exclusive just to that area, but that's one that people are very familiar with. Say pharmaceutical companies are not used to non-exclusively licensing their inventions across their industry. They're used to either making things themselves or maybe exclusively licensing one company. And that exclusivity is very important to them. So we've had to think very differently from deal to deal, right, about how are we going to set up the intellectual property rights and the confidential information rights so that we can actually get this deal done and collaborate, because that's where the value is right now, right? We talked about this in all industries. This is where the value is. Help people with instrumentation, help people with analytics. Who's going to own that? Where are the rights to that? What are you going to do with that? And we've got to get the deals done. So we're coming up with solutions. The solutions involve some creative lawyering, but they also involve advising our client to understand that they may have to work a little bit differently. These are hard things to do, but there's money here on the table, so we do them, right? We want to collaborate. We want to make the money, so we do it. And I believe we're approaching a new business model. Right? So it all sounds great, right? Going into a new era of innovation. New elements of collaboration across industries. We're going to come up with a new model. But we have a problem. And the problem that we have is the current IP environment that we're living in. You would think that there should be no obstacles to this, that the IP environment should welcome this kind of convergence, should allow us to do work, and particularly in the artificial intelligence space, and that should be a way to incent innovation. But what we're running into is a problem. I mean, in my mind, the most significant problem in this area is the subject matter eligibility jurisprudence, which you've also heard people talk about, particularly in this morning's session. We've always benefited from having unitary US patent system. It isn't 100% technology neutral. There are a few nits in there that are exceptions to that, but basically we try to treat our patent system as technology neutral. And that's important for creating this kind of platform, this fertile platform for developing new technologies, new fields of technology, because you don't know where they're going to be. So the thing you really want to avoid is putting them in a silo by having different rules for different technologies. And that's the problem that we are having right now with subject matter eligibility law. I don't think I have to go into this in much detail because people have done this already today. But if you start making different rules for software, different rules for diagnostic methods, then you will prevent people from collaborating. They'll come into an engagement and say, I have different rules from you, right? So all that hard work I was doing to come to an agreement with another company, now they have different incentives from me, and now it's becoming possible, maybe impossible. And I'll just leave you with this one last slide. I don't want to go into these cases, but here are inventions that have been found ineligible either at the patent office or in courts, which are kind of at the intersection, right? They're in this kind of convergence zone at the intersection of IT and other technology fields. MRI machine, real-time performance monitoring of an electric power grid. You heard me talk about smart cities. Detecting fraudulent access to patient records is sort of a healthcare, information-related invention. And Synopsys versus Mentor Graphics, which is about semiconductor design. These are all areas where the courts have attacked what are inventions at the convergence of these fields. So we're vulnerable here. This is a real thing. And I view this as an impediment to what I think would be a great next generation of innovation that we see, certainly at IBM Research. Thank you.
Thank you very much. Well, that sounds like Congress may have some work ahead of it, so we'll keep our fingers crossed. So now the panel gets a chance to put some interrogatories to other panel members.
Oh, that is kind of you. I see we don't have too much time for the audience, so I should crowdsource most of my questions. But Marian, I just want to briefly say that despite your disclaimer, I intend to rely on your presentation for legal advice. and Michael, just anecdotally for your study, when I got my second notice that someone on my personal network was illegally streaming things, I just switched ISP providers, and that seemed to solve the problem. So there are creative solutions available.
All right.
Oh, that was it. Sorry, continue.
You're extremely irresponsible.
Yeah, so I'm Ryan, I don't disagree with your general point. I think the evidence of the singularity and even exponentiality is not really there. If you look at semiconductor progress, for example, it's the first time in U.S. history since we invented the semiconductor that the price per MIP has been going up, not down, millions of instructions per second. I just don't, and maybe at some point we're going to get there. I'm just skeptical we're going to get there anytime soon. And so maybe we'll worry about this, but I'm not worried about it too much now. And I guess, Michael, your point is, or point to you, Michael, we talked about this earlier. I thought that was a really interesting study. I would love to have another study where it's not just 3 strikes and you've been given 3 strikes, but it's 3 strikes and you go to jail for 10 years. Just kidding. Just kidding. Like, no, 3 strikes and, you lose, your bandwidth is degraded for 2 months. Some real consequence other than just, that would be an interesting study to do.
Right, to compare it to, this is sort of a toothless notice sending program.
Yeah.
What would happen if you actually put some teeth behind it?
Yeah.
It'd be a fascinating study.
Yeah. So I guess for Marian would be, I guess the question would be, do you think that, we can't really patent data, so what you're talking about are patenting things that do something with data and the ability there, so.
To me, the area where that's vulnerable and that creates a problem is artificial intelligence. And I think there's a lack of there's the really vulnerable inventions are the ones that the courts can look at as algorithms, right? So, which I think are really functionality in the way the software works. There's innovations at the hardware level, they're probably not vulnerable. There are innovations at the system software level, depends on your judge, depends on the patent office. But I think there's a lot of value at the what I would call the algorithm level. And it's about new functionality, it's about technology, it's not an abstract idea. And I feel like by cutting that off, we really are losing an incentive in that area. The other thing I should point out is that this is a really hot, like bleeding edge area of innovation. People want to publish, right? There's a lot of work going on at universities, and at universities, people more likely to rely on publishing. They do want to get patents more and more these days, but they might just fall back on that. But if you want to have commercial innovation in this area and you want to incent people, I think having patenting is very important. You're not going to keep it as a trade secret.
Sure. I guess just a quick question. With deep learning, it'd be interesting. The question is, what part of that is patentable? Because you initially have your initial algorithm, and then you send it out there in the world, and it then self-mutates because of deep learning. Are both patentable? Is one patentable?
People talk about trained models. I mean, just a data set itself, that you want, I don't know, that doesn't really lend itself to a patent protection. But people do talk about trained models, and they are a little harder because they do kind of represent an end result. It's almost like a product by process kind of a situation, but it does kind of get you back to, well, how did I get there? And I realize that there's a value to a customer in particular when they get to that trained model. That's sort of like their value in their data. And I think that to me is kind of a tricky area. That to me is, well, maybe if it's something that's really data laden, it's more like, or very specific to the data, it's something that's more appropriately, that maybe is more appropriately kept as a trade secret. But that's I think, that to me is the difficult area. I also think there's developments going on in the area of trained models that change what they look like. And I'm not technically equipped to really address that, but I don't know if you could have one that would really be data independent. And if you did, then you might think to yourself, well, okay, do I want a new form of protection? Do I want something, I hate to even suggest this, but a sui generis form of protection, is there something new that would make sense there? I don't know.
I thought, Ryan, and I think it got reflected in everybody's, just the incentives to invest. And I think it's if you think about Avi Goldfarb and Catherine Tucker's paper, I think it's really interesting to think about whether reducing the value of the of targeted advertising is going to 5-10 years from now cause investment to shift even more towards U.S. companies versus EU. Like, what are the perverse incentives that are going to be put in place from this, and do those outweigh any advantages of privacy that are going to accrue to the EU? I don't know. I'm also, I don't know, I too am a little bit skeptical of AI-driven creativity. Not so much that we can't do it, but I'm not sure there's a market demand for it, in the sense that I think what AI algorithms do really well is they optimize towards an objective, and they scale really well. I'm not sure either of those things are all that valuable when it comes to creativity relative to some other areas that we have.
Well, to answer both of your questions, I'll take them in the order they came. On the singularity point, few technologists think the singularity isn't coming. The million-dollar question being, when is it coming? And I have no real personal opinion on that. Some people think 10 or 20 years from now, other people think 50. So I'm not too worried about it late at night. But when it does come, assuming it comes, the last bit of that is what we're headed towards. And I disagree with this isn't that relevant to creative things. We have some creative industry people here, so we should ask them and say, what role are machines doing in making music and films, and how much of this is computer generated, and how much are the machines kind of autonomously creating in the background? I think a lot of games and music and such are actively being creatively done right now. As for invention, you don't hear a lot about it. Some companies tell me they're doing a lot of it. There have been claims of people doing it for decades. And I suspect now that we're witnessing another surge in AI with a lot of increased functionality, it's going to become bigger soon. But time will tell.
Yeah, it'll be interesting to see. I know that we're using algorithms to inform the creators, but I don't see the algorithms replacing the creators. And I could be wrong about this, and my students make fun of me because I spend the first part of the class talking about people who've made foolish predictions that later get proven. So I recognize I'm on thin ice here. The only thing I'd point out is that Deep Blue can beat the best Jeopardy player, and yet we still play Jeopardy. There's still a human element to watching humans compete that is fun and interesting to us, even though we know that Deep Blue's the best.
Can I just quickly? You were
No,
fine.
after you.
I was going to say, I don't agree that most CS or AI people think the singularity, even semiconductor people think the singularity is inevitable. There's lots and lots of real experts who think the singularity is not going to ever happen. It's sort of nonsensical, Ray Kurzweil dreaming. Pedro Dominguez's book, I think it's The Master Algorithm. So there's a lot of people out there who just don't think the singularity is even possible. So I'm willing to acknowledge it's an interesting debate. I'm on this skeptical side of it's never going to happen. I think it's never going to happen, but you can never say never. I don't think it's going to happen in our lifetime, so I don't think we should worry about it.
All right, so at least one of us will be proven to be a fool in the future, but we won't know who, and it could be the machines telling us which one it is.
All right.
I mean,
so
no,
go ahead.
I've spoken enough.
So let's crowdsource the audience here a little bit. What are your plenty of hands?
Thanks. Well, since I'm the first iteration of a crowdsource, I was wondering if the panel could comment on kind of the idea of open access around big data. And, in particular, I'm interested in kind of the academic life sciences and clinical medicine perspective, where there's currently a major push to make data fungible, freely shareable and that kind of thing.
I mean, I sort of skipped through the slide I had on that. It's sort of in the paper I'm working on. I think, this is why I think one of the things why this is a hard problem. I mean, maybe it's harder than sort of IP in general, because there's clear evidence that bigger data pools, shared collective data pools, provide an enormous benefit to society. But at the same time, you have to worry about the negative effects on innovation. So I think there are a bunch of areas where you could deal with that problem, partly just through coordination mechanisms, partly through better professional norms. Partly, I think, in some of these cases, there's just no sharing because there's no sort of natural data trust, if you will. So the UK, for example, is establishing these data trusts. So it's like, if you want to share your data, this is how you do it. So I think you could do things like that. And then in the publishing area, obviously, in my view, more government funding so that you're not having to have many private journals or funding so that you can put data sets in there. So I 100% agree, more data sets in more. The same thing with smart cities that IBM's involved. We're doing smart cities, but it's mostly siloed. So you have data in Chicago and data in Amsterdam. And the real interesting thing is if you could put all that data together and do analytics around how 50 cities operate, you're going to get much better insights and actionable things than you would have just doing it one at a time.
On this side, the gentleman in the pink here.
This is for Professor Abbott, and I mean it not in tongue-in-cheek. As a life and being and an inventor, I cannot patent an algorithm, so why should an algorithm be able to patent anything? I mean, these are generated constructs from human effort, directly or indirectly. I don't think they're self-generating.
Well, that logic would more seem to go, why should an algorithm be able to patent me? But they can't do that either. Well, so Sean, among other, challenges the incentive innovation theory of patents, but assuming we just go with the dominant narrative of that, and that, right, we have patents primarily and for many reasons because we want to incentivize innovation. If we're looking at a future where more and more innovation comes from machines and the innovations of those machines have value, and we want to have people create inventive machines, then patents to me seems like the most appropriate way to do it. I mean, at the end of the day, it shouldn't matter whether it's a room full of monkeys or Einstein or Watson that's coming up with an invention. What we really care about societally is generating more new, non-obvious, and useful inventions. And so I don't think it should matter whether you or Watson is filing a patent application.
Okay, the gentleman next to you.
This is directed to Mr. Abbott. The last discussion, I talked about SAR, and now I'm hearing from you that computer programs can generate IP. Well, in the pharmaceutical industry, they've been generating IP for a very long time. And it just hit me that that's a potential philosophical problem. There are computer programs that will create drugs. And I've always considered them to be tools. Maybe, given what you've just said, maybe they're the inventors, not simply a tool. Could you please respond to that?
So the way I prefer to think about it is by analogy to human invention, right? So you can have a team of scientists at a life science company inventing a drug, and only some of them are inventors, right? And we have a test for that. Who's responsible for the conception of an invention, right? A lot of what it is just reduction to practice. So if you have, a lead scientist with a bunch of other scientists and they're carrying out experiments or following instructions or doing things known in the art, right? That's not inventive material on their part. So I think a lot of people using machines and coming up with something is really just the person coming up with it. But at the point where a person gives a machine a problem and the machine generates a solution from the problem, it's really not fair, in my mind, or efficient economically to say that the person giving the machine the problem is an inventor. And so, what do we do with that? Do we say, well, no one should be able to patent this like we do here for copyright and say this is public domain? Do we say, well, really the developer or the user, the owner of the machine should just get to be the inventor? Or I think, well, we ought to acknowledge where the conception came from and that the incentive structure works best when the owner owns the patent. But that's my own personal opinion on it.
Let's go to this side. Somebody, first row.
I'm actually not sure who this question is for. I think it maybe is a combination of Professor Abbott and Ms. Underweiser. It seems to me that a lot of the issues that Professor Abbott is raising potentially could be being faced by IBM in terms of some of these agreements that you're talking about. Watson is doing lots of interesting stuff, from all the reports I read. And I'm just wondering, Mr. Atkinson sort of poo-pooed Mr. Abbott's concern, or Professor Abbott's concern, saying it's obviously based on the singularity, but given the comments that we just heard and given Professor Abbott's comments, I didn't hear it that way. It seemed to me that you could have machines that are doing inventions, creating things that are far short of the singularity of the self-perpetuating super-intelligent computers. And I just wondered, first of all, whether I was interpreting Professor Abbott's concerns correctly, that we don't need to get to the singularity to actually face that issue, and to ask you whether you're facing that issue in the kind of agreements you're drafting and facing for IBM.
So if you really want to talk about poo, Professor Lietzen is still here. And we could ask her about it. But, well, I was going to say I don't speak for IBM, but then you said you don't speak for IBM either, so I might as well just answer the question. I'm frequently on people with panels from IBM and so rarely with other technology companies. IBM is really good at putting people on them, but their European counsel who work on their contracts tell me this is a big issue for them, right? And that was my slide there. And they tell me essentially clients dump massive amounts of data on them. They run the data through the algorithms. The algorithms say, these are insights, here they're yours, client, and you can patent them, and sometimes they patent them. And, all of that is done contractually. No one's looking at this, no one's litigating this, so it kind of doesn't matter. But if someone did litigate it, you could say, well, the client really shouldn't be able to get to patent this, and who should we even put on as an inventor on the thing, right? I think these are, companies tell me that they are dealing with these things now. The end of obviousness is more of a singularity type of thing, but that's just because I'm an academic and it's fun to talk about.
Well, and I'll just comment on that. We don't, I don't think that I think it may be that the singularity is coming, and it may be that there comes a time when we really have to address the concept of whether or not the computer is an inventor, but that is not where I see the technology right now. So sure, in our deals, we have to cover whether, Watson is actually a separate business unit from research. So Watson does things the way they do it, and you do have to think about, the thing you have to think about when you think about the Watson is that you have a very sophisticated technology that is learning, right? So there are things that Watson picks up as it does its work that, that you need to be able to reuse. And there are things that are peculiar to a client that maybe you don't need to be able to reuse. And that's some of the things you've heard maybe other IBMers talk about. That's something that our chair, Ginny Rometty, has talked about. But when you ask the question about, do you have engagements, and from what I've seen in the research division, where you might have to deal with whether or not the computer is an inventor, I don't think the technology is there yet. So we don't really have that conversation. Maybe we will at some point, but we don't have that conversation now.
Well, in fairness, that came from someone who was doing European Watson contracts, but they're not doing anything about it. They just say in the contract, all the inventions belong to the client. But then they think, well, Watson's kind of doing the work, but what are we going to do about it? So,
On this side, gentleman over here.
So to Professor Abbott, when we talk about, you say the insights are patented, I think we have to have a finer grained ontology. In most of these cases, the domain is really highly specified. So what is being solved for is, here, the domain is, Go. That's a very limited domain. The domain is chess. That's a very limited domain. The domain is drug discovery. It's a very limited domain. And what is being discovered or invented are artifacts, instances of things. That is one class of invention. A more interesting class of invention is where the problem is not specified and the system actually identifies a problem. It discovers a problem. That's a different class of invention. And so that's an actual invention of a methodology. And then from there, having discovered a problem, the system then creates an artifact to solve the problem. That's another kind of invention. And even from there, creates a methodology to create artifacts. So there's many different levels of which we can say of what is inventive. And I think it's necessary to make those distinctions in order to figure out where would we attribute inventiveness. I don't agree that, so when you said if the algorithm comes up with an artifact, that's been done for quite a while. There's expert systems that you say, here are the constraints of the system, solve the problem, and the system comes up with an optimized solution. That's not necessarily inventing it at that layer. So I think we have to have an ontology in order to address this. And then let me just finally add, if the whole purpose of patents is this economic incentive and social benefit, which really means you can alienate your rights in a patent, right? You are the inventor, you can sell it off. Systems, artificial intelligence systems can now negotiate. So if we can have a system that can invent and then can negotiate for its rights, we can have inventorship.
well, luckily, I'm not planning to give it any rights, but I take your point well, and in 15 minutes, I didn't have time to get into that, but in some of the papers I've written, I kind of tease it out a bit. To the extent it's a simple question with a known solution that an expert system would be able to solve simply, right? That's probably an obvious solution to a thing. right? And I suspect more and more we will see machines being, without quite being general artificial intelligence yet, being used to solve problems they weren't originally designed to solve, being used in broader and broader domains. And yes, eventually, people not knowing the problem, what the problem is, and just asking a computer to help with things. Certainly sometimes, particularly in European patent law, just determining the problem to be solved is the inventive act, right? You know, and sometimes it's really hard to figure out what the problem is, as I tell my law students, but they never believe me. But you know, some of the time it's not, right? So if I say to a computer, you know, my phone keeps dying, can't you design a better battery? And you know, Siri goes out and says, sure, here's a schematic, you know. That doesn't happen routinely now, but we're moving that way.
Well, excellent questions. I'd like to ask for a hand for the panelists, who I think did a great job. And, you know, I guess we'll be back next year and see who was right on various things.